As much as any other narrative, the story of immigration is the story of America. And that tale has often been a struggle between segregation and integration. Most are familiar with Brown v. Board of Education, the landmark Supreme Court ruling that ended the practice of separate but equal segregated schools. But a lesser-known case involving immigrants from Mexico set the table for Brown, and today we'll take a look back. This week on Dialogue, Mendez v. Westminster, School Desegregation and Mexican-American Rights. Hello again, and welcome to the Woodrow Wilson International Center for Scholars in Washington, D.C. I'm John Molesky. Each week, Dialogue explores the world of ideas and issues in international affairs, history, and culture. Our guest today is Philippa Strum. Philippa is a senior scholar at the Woodrow Wilson International Center for Scholars. Her areas of expertise include civil liberties and civil rights and U.S. constitutional law. She is the former director of the Center's Division of U.S. Studies and is the author of several books, including this one, Mendez v. Westminster, School Desegregation and Mexican-American Rights. Philippa, welcome to Dialogue. Thanks for joining us.
Thank you so much for having me here.
So I'm going to start with the linear telling of the story. September 1943, Soledad Viduari,
I think,
is heading to school. Tell us what happens.
She goes in with two of her children and the three children of her brother, whose last name is Mendez. And they're new to the neighborhood, taking the kids in to register at the school, and the teacher in charge of admitting people turns to them and says, well, I'll take those, pointing to Mrs. Viduari's two kids, but not those, the Mendez kids. And the reason was twofold. One, the Mendez kids had darker skin. They were clearly Mexican-American. The Viduari kids had really light skin, and their name was French-sounding to the teacher. So what the teacher said, in effect, is Mexican kids can't go to the white school. Mexican kids have to go to the Mexican school.
About an arbitrary screening process. The principal just doing a visual observation and making a call on his or her, knowledge of ethnic names.
That's exactly right.
It sounds insane compared to today's standards. Set the scene for us. This is pre-Brown v. Board of Education. What is America like at this time? What is Orange County, California like at this time as it relates to ethnicity, race? Give us a sense. I mean, I think the book does a terrific job of that type of time travel. It really takes you back.
Well, thank you. Of course, you know that there was segregation throughout the South of the United States, but there was segregation elsewhere. And California at this time was overwhelmingly dependent upon the services of Mexican Americans, including both those who were citizens and those who were recent immigrants, to staff its agricultural industry. Now, more than 1 million Mexicans had migrated to the United States between 1910 and 1930. So they made up a good chunk of the California population. But they were segregated in colonias, in little concentrations of houses and little bodegas occasionally. And what the school authorities had done in their wisdom in California was decide that they didn't want the Mexican kids in schools with the white kids. And so they had drawn areas that were school districts so as to keep the Mexican kids and the white kids quite separate. And that was indicative of what was happening to Mexican Americans, whether they were in school or not. Mexican Americans weren't allowed to buy property in many neighborhoods. They were not allowed to go into the movie theaters. They weren't allowed to use public swimming pools or parks. It was real segregation and discrimination.
But the Menendez children with their Aunt Soledad end up at this Westminster main school. How were they in that neighborhood and they weren't in one of these segregated areas that you talk about?
This is such a wonderful part of the story, I think. Their parents had run a cafe in a nearby place, not right where the story takes place. And their father, Gonzalo Mendez, had always wanted to run a farm. Well, a Japanese-American family was taken away to be interned, as happened to the Japanese Americans throughout California during the Second World War. And they were, of course, worried about what would happen to their farm while they were away. And Gonzalo Mendez's banker said to him, hey, you've always wanted to run a farm. How about leasing this farm from this family? And that's what the Mendezes did. And so they moved into what was otherwise an all-white neighborhood of Westminster, California. They with Mrs. Vidori and her husband, who was going to help run the farm with them.
I mean, the connecting of the dots here is amazing. That Japanese internment would lead to the Mendezes moving to Orange County.
Right.
And this Gonzalo and Felicitas, was that Mrs. Menendez?
Right.
Or Mendez? Anything unique about the Mendez family? You know, often when you look at these stories of important rights, claiming of rights through the court systems, you see what appear to be ordinary people caught up in extraordinary circumstances. But then the more you look into it, you realize that there are extraordinary attributes to some of these folks. What about the Mendez family? What could you tell us about them?
Well, you never know why some people stand out, actually. But Gonzalo Mendez had been brought to the United States as a young child. He went to school in Westminster before it was so segregated, dropped out relatively early because he had to help his family with earned income, went to work in the fields. There he met what turned out to be Felicitas's father, who was working alongside him. Now, the father had brought his family from Puerto Rico some years before. And so when Gonzalo met Felicitas, he met somebody who very much considered herself an American, was an American citizen, even though she was an immigrant, if you will, to California. They didn't think of themselves, apparently, as very special. They just thought, we're all Americans. And one of the things that Felicitas said in the court trial that ultimately ensued was, we always tell our children they are Americans. And she thought, all right, American kids go to the nearby school. I want my kids to go to the nearby school. We're going to fight for that.
And also, the other nuance here is that this wasn't a case of racial discrimination, because at that time, the Mexican Americans were classified as white. So this was about ethnic discrimination.
That's right. And one of the things that becomes really important in the case is the fact that the Supreme Court had said not many years before, racial segregation is okay. Separate but equal is okay, as long as the races are treated equally. And this was something that was going to be a little bit of a problem for the Mendezes and for their lawyer. If segregation is okay, according to the Supreme Court, how can you fight it for Mexican Americans? And their answer was, but we're not a separate race. We're part of the white race, and there's nothing that says that you can segregate people and discriminate against people within a race.
But part of what the school district is saying is that, well, it's also about language skills.
Yeah, what they said essentially is these kids can't speak English, so for their good and for the good of the other children, we'll segregate them and give them a little extra help until they can speak English, which is total nonsense. First of all, the school districts didn't know whether the kids spoke English because they gave them no tests. And as it turned out, most of the kids did come to the school speaking English, some not as well as others, to be sure, but a lot of them spoke English very, very well indeed. And then as emerged in the trial, it was clear that the authorities also thought of these kids as morally different, as dirty, as diseased, and this was the way they thought about Mexican Americans generally.
And also, you know, another fascinating aspect, I'd highly recommend the book to those of you who want to read it, but as someone who did, is these things that you bring up, this notion that Mexicans were not as clean, these weren't talked about behind closed doors. This is part of the public record. This is on the stand during a trial and elsewhere.
Yeah, and it's ironic. There we were in the 1940s when people are talking about Mexican Americans are biologically different. And at the same time, we're in World War II. We're fighting World War II for democracy and equality and so on. And the disconnect is pretty strong.
Yeah. So back to the linear part of the story. How long does it take this to go to trial once the Soledad goes home, tells the Mendezes what happened, and they decide to pursue legal remedies?
Well, that, as you say, is September 1943. The Mendezes did what they should have done. They went to the school authorities and said, can we talk about this? And that took a while. And, excuse me, the school authorities said, no. And ultimately, the Mendezes went to look for a lawyer. And I really like this part of the story because the lawyer they found was a Jewish American, son of immigrants, who said to them, will have a stronger case if you can show that there's a pattern of discrimination throughout Orange County. If you can show that other families have been treated this way. And so for about a year, Gonzalo Mendez and the lawyer, David Marcus, went around the county trying to find other plaintiffs and discovered, lo and behold, this was happening to Mexican-American parents all over the county. And so the case doesn't actually get into the court until 1946.
46. So there's
Right.
and then also I guess there were 7 months after the trial ended until the judge made the decision.
Right.
So this really was this a function of how sensitive a ruling this was going to be? Were the people involved aware of the fact that they were going to be making a fairly significant judgment?
The judge certainly did realize that, and I'm sure that you're right.
And
That's
it's Paul McCormick. We should probably say give some
another
background on
wonderful
him as
part
well.
of the story, because Paul McCormick was an Irish Catholic who later was awarded something by the Pope for all of his activities in Catholic charities. So you've got the Mexican-American and the Puerto Rican going to this Jewish-American lawyer, going to court where they're being listened to by an Irish Catholic. And as we'll see later on, we get other ethnic and racial groups in here as well. It really is an all-American story.
Yeah, well, it is. It's as we said in the opening, this whole notion that this is the story of America. This is a panoply of different generations of American immigration coming together under this trial. So then, who are the attorneys for the defense? We know that now Mr. Marcus is the attorney for the plaintiffs. Who's representing the state's interests?
A gentleman named George Holden, who was in the office of the Orange County Council, handled the trial. And I haven't been able to find out as much about Mr. Holden as I did about Mr. Marcus, although I was in touch with members of the Holden family who gave me as much information as they had. I'm not really sure how Mr. Holden felt about this whole endeavor. I don't know whether he believed what he had to argue, which was that the segregation was a good thing. He certainly gave it his best shot, went down in flames ultimately, I think quite appropriately. But I don't have any sense that he was himself a bigot, or he did what he was supposed to do.
He was doing his job.
Right.
This whole notion of that the onus was to prove discrimination, not segregation, because segregation as a practice was widely accepted. So talk to us about the whole strategy, how Marcus and the Mendezes and the other plaintiffs in the case went about strategizing.
All right. Well, as you said, just the fact that the kids were segregated proved nothing in legal terms. But how do you go from segregation to discrimination? And what Marcus had to argue was, because the kids are segregated, they're not getting as good an education. Now, the 14th Amendment to the Constitution says that states have to treat everybody equally. This is the equal protection of the laws. And if you can show that separate but equal in this case is not really equal, then you can show that the 14th Amendment is being violated. Then you can show that segregation is discrimination. And so what Marcus had to do was, first of all, show that the superintendents of various school districts in Orange County had colluded to put Mexican kids in separate schools, because this was conspiracy to violate the law effectively, and then show that the kids were indeed getting a lesser education, were being prevented from getting an equal education by the very fact of the segregation.
Mm-hmm. And when you were looking through the transcripts from the trial, what witnesses, what testimony, what exchanges stand out to you as being pivotal moments?
One of them was the testimony of a mother who had taken her young son to the white school and had asked the superintendent to be allowed in, and the superintendent, of course, said no. But she had not only a young son, she also had an older son who had been drafted. And what she heard from the superintendent was, we can't let you Mexicans into our schools because you're so dirty. And her response to him was, if we're so dirty, why don't you take my son who's over there fighting for the United States and the Philippines and send him home? And that was the kind of testimony that you got from the parents over and over and over again, that one superintendent after another had said to them, your kids are too dirty to come to our school. And the dirtiness was a recurrent theme, a really very distressing theme.
What does this say to you about this whole intersection of cultural and societal changes, and then the law, the chicken or the egg, which comes first? Because what you describe in the book is segregationists falling into ill repute, where once they were the norm, the order of the day. Statements like this made publicly started to not sit well with the American public, particularly based on the dramatic example you give of people of Mexican heritage fighting in a war. Clean enough to do that. What does this say to you about that whole juncture of societal changes and legal changes? How does one affect the other?
Well, remember, we're looking at this from the vantage point of 2010.
Right.
And back in the 40s, and I can remember this growing up as a kid, it was still perfectly normal for the average American to say, yes, there are biological differences between the races. Yes, we have segregation, that's just fine.
It was just accepted as pseudoscience, no real proof, but people just accepted it.
I think that some of the people would have said there is real proof, whatever this proof may consist of. There were IQ tests that were supposedly showing that different racial groups had different IQ scores. So there was pseudoscience involved in all of this. And I think that while we're talking about something that helped change the law, it didn't necessarily result from changed societal perceptions. There was a beginning of change in the sense that many of the members of the legal elite were starting to think about segregation, perhaps looking at the World War II experience. Maybe we don't really want to be talking about racial disparities and things of that kind.
Sounded very Aryan.
Exactly. I mean, I think the average American was still very much into that way of thinking, and that's what makes Mendez so extraordinary. It's this group of parents, given that climate, just stood up and said, no, I'm not going to let this happen. And it's all the more extraordinary that a federal court judge, knowing that the Supreme Court had bought into the idea of racial differences and segregation is okay, said, I don't think it's right either. It was amazing. It was a really amazing moment. It was the Brown v. Board moment for Mexican Americans.
And was there ever a moment where Holden and the defense had any momentum in the trial? Or was their defense on shaky ground from the very start?
It wasn't, in the sense that Judge McCormick thought going into the trial and throughout much of the trial, education is a state matter. We're a federal court. That's the court that they went into. We shouldn't be dealing with this at all. And it was he who had to be convinced, obviously. This was not a jury trial. This was just the judge. And he was extremely dubious, and he kept saying, well, okay, we've agreed that there's segregation, but are we sure it's discrimination? Doesn't it make sense to have children of different capabilities in different classrooms? And what the plaintiffs had to do, what David Marcus had to do, was bring in experts to show that no, it doesn't make sense at all, that in fact what you're doing is you're giving the Mexican-American kids a sense of inferiority that's going to interfere with their ability to learn. Exactly the same thing that did the job in Brown v. Board, but Brown v. Board came somewhat later. So
Judge McCormick was reluctant to second-guess educators until Marcus produced the educational experts that said otherwise.
Exactly, exactly.
So this was also treated, this was a violation of California law as well, not necessarily constitutional law. Or does that come in the appeal process?
No, you're absolutely right. Judge McCormick mentions the California law later. It gets into the appeals court much more significantly. But what was interesting was that California did have a law specifically permitting the segregation of Indian children and Asian children. The law was passed in the late 19th century before there were a lot of Mexican Americans in California, and so nothing at all about them was said. And David Marcus could have gone into court and just said, okay, they're not in this law, so they can't be segregated. He very deliberately didn't do that. He wanted to attack segregation as such. And that's what he managed to do very brilliantly here.
Was there a lot of press attention at the time? Was anyone paying attention, or was this all under the radar?
It was basically under the radar. There were a couple of local newspapers that paid attention. The LA Times didn't pay any attention. Certainly the other media didn't pay any attention until it went to the appeals court. You go from federal district court up to the Court of Appeals, which is, in this case, the Ninth Circuit Court of Appeals, which has jurisdiction over California as well as some other states. And at that point, yes, everybody kind of sat up and took notice. Wow, an intermediate federal level court, right below the Supreme Court, is hearing a case about Mexican-American school desegregation. And at that point, even the New York Times sent a reporter to cover the case. So then it gets on the national radar screen. And what was even more important was, with virtually no press coverage, virtually nobody knew about the case until Judge McCormick handed down his decision. Then the NAACP, based in New York, sits up and says, hey, this is a case against school desegregation. Mm-hmm. Maybe we should be in this case. And at that point, Thurgood Marshall's second in command, Robert Carter, later a federal judge himself, writes a brief that will go into the case at the appeals level. So does the Japanese American Citizens League. So does the American Jewish Congress. All of a sudden, civil liberties, civil rights organizations all over the country are saying, hey, this is a really important case. We need to be part of it.
And the NAACP brief was described by those involved as a trial run for Brown.
Exactly. That's what Carter said. This is where he tested it out. And this is where he wanted to prove that it was possible to use educational experts' testimony to show that separate but equal couldn't be equal in an educational situation.
As all this played out, and eventually it goes in the favor of the Mendez family and others, where are the kids going to school?
The kids, with the exception, well, let me back up here a little bit. The kids are going to segregated schools. Kids are going to segregated schools. After Judge McCormick handed down his opinion, the Westminster School District, one of the 4 school districts involved in the case, decided to integrate, so that at that point the Mendez kids started going to the white school. But the other school districts, not at all. The other school districts were not in a hurry to rush into integration.
Mm-hmm. Speaking of all of the very interesting ironies and contradictions and surprising elements of this story, tell us where Earl Warren was as this was playing out and where he ended up.
Earl Warren was governor of California while this was happening, and Earl Warren had no direct involvement in the case, except that it's clear that it was behind the scenes because his attorney general put a brief in at the appellate level saying, yes, you should strike down this segregation of Mexican-American kids. Well, the Attorney General of a state doesn't do something that radical without the governor at least knowing about it, perhaps approving it. And some of the stuff that Earl Warren wrote later would seem to indicate that he did indeed approve it. And then, of course, Earl Warren goes on to become the Chief Justice of the United States, who writes the opinion for the court in Brown versus Board of Education, which parallels, paragraph by paragraph, the language
in the book, you have the paragraphs next to each other. Even though he doesn't reference Mendez directly,
right,
the language is very similar.
Absolutely, absolutely. So you can see a real train that goes right from the station that's Mendez into the station that's Brown v. Board.
You mentioned that in the course of researching and writing the book, you find yourself enraged at times at what seem like obvious injustices treated as business as usual. But there's a happy ending to the story, at least in that this case is recognized as, on the cover, show it to people, a U.S. postage stamp. Finally, this case gets its due.
Yeah, really, really exciting. This was issued in 2007, and there is a board that advises the U.S. Postal Service on what kind of commemorative stamps to issue. Well, it turns out that one of the people on that board is Thurgood Marshall, Jr. So in saying, yes, let's go ahead with this, he was kind of picking up where the NAA left off in the Mendez case.
Well, how did you get interested in writing about this case?
I read a story one day in the style section of the Washington Post, which is not the part of the Washington Post that many of my colleagues read.
You're admitting this publicly, that that's the part you read.
Well, I had come to Washington as an immigrant, if you will, from New York, and thought I should know what all the people around me are reading. And I didn't yet know that my colleagues didn't read this section of the Washington Post.
I love the style section, by the way. I'm no snob about this.
Well, I read it, and then one day there's an article about exactly the stamp that you just showed us, saying this is an issuance of a new stamp. And it's about a case called Mendez versus Westminster. And I said, no, wait here. Something's wrong. I have taught constitutional law for 35 years, and I never heard of this case. What is going on here? And I decided, well, I've got to do some research. I've got to find out about it. I discovered that Mendez, that I didn't know about Mendez because it's not in the constitutional law case books. It's not in the biographies, by and large, of Earl Warren. It's just not there. But as I read the case, I said, gee, this is so important. Yeah. This is the Brown v. Board of Mexican Americans, and this is a forerunner, a really important forerunner to Brown v. Board. And I got so into it that after a while I said, I have to write about this.
Yeah, I'm glad you did. A similar reaction. I was involved in a documentary on Brown v. Board, and I did not know of Mendez until more recently. I'd heard of it peripherally, but then to dive into it through your book, it is a fascinating case, and anyone interested in the subject matter has got to spend some time with this case.
Yeah, well, this might be a big admission, but I do tend to hang out with law professors, and they haven't heard about this case, or they hadn't before the book anyway.
Let me ask you, before we run out of time, about as you're reliving your research and reliving the case through your work, do you see echoes of the past in our current immigration debate, or particularly some of the very controversial things that have taken place in Arizona? How do you tie the two together in your mind?
Oh, there's an absolute connection. What you get in both instances is the labor of Mexican Americans being used, and other Latinos as well. It's not just Mexican Americans being used, being crucial to the economy of a place, as it was to California and Mendez, as it is to Arizona now, but a great disdain for precisely those people who were performing that kind of labor, fear that somehow the society is changing because these people have been let in, and an attempt to treat them differently, to say, no, you're not quite like us, it's perfectly legitimate to treat you differently. But at the same time, one of the nice things that goes through all of this is the involvement of other groups, just the way the NAACP got into Mendez and the American Jewish Congress got into Mendez. If you look at the case that's being brought right now about the Arizona law, you discover that in it is the American Civil Liberties Union, the Japanese American Citizens League, the NAACP, a Muslim American group. So on the one hand, you've got this really bad carryover or parallel. On the other hand, you've got this business of the coming together of different people to fight what is clearly an injustice.
Philippa, thank you, and congratulations on the book. And as you said, it's something we should know about. Now, thanks to your book, we can know about it. Appreciate it. In addition to thanking our guests, I want to thank you for watching and listening, and also let you know that we appreciate your comments and encourage you to share them with us. And you can do so by sending email to dialogue@wilsoncenter.org. We'll return next week with another edition of Dialogue. Until then, for all of us at the Woodrow Wilson International Center for Scholars, I'm John Molesky. Thanks for joining us.
Dialogue is a co-production of the Woodrow Wilson International Center for Scholars and MHZ Networks. Dialogue is available via broadcast, cable, satellite, and telco on MHZ Worldview throughout the United States. To see how to watch where you live, visit www.mhznetworks.org.